All right, I just got the thumbs up from our technical crew. Good morning and welcome to our Business Law Breakfast series. Today we're speaking about hot issues in property, which is our second property topic for the year. For those who have been before, as you know, we have a fairly wide-ranging set of topics and try to cover different areas of law and different areas of interest with each breakfast. I'd like to begin by acknowledging the traditional owners of the land on which we're meeting, and to pay my respects to their elders, past, present and emerging, and to the Aboriginal elders of other communities who may be here today. I look forward to walking with you in the hope that we'll walk these lands together very, very happily for a long time to come.
Good morning, everyone. My name is Zhou. I am a lawyer from Aitken Partners. Today I'm going to cover the topic of demolition notice and injunctive relief in the retail leasing. This topic has been alive recently because of a VCAT decision, which is an application by a retail lease tenant against a proposed demolition work by the landlord. So in a recent VCAT case, then holistic, the tribunal considered whether a demolition notice issued by a landlord under a retail lease is compliant with Section 56 of the Retail Leases Act, which would entitle the landlord to terminate the lease early with sufficient notice. In this case, the demolition notice was issued by the landlord and the tenant filed an application with VCAT seeking an interlocutory injunction against the proposed demolition. There is a demolition clause in the lease which allows the landlord to terminate the lease if he wants to demolish the premises, as well as complying with the issuing of a demolition notice in accordance with the clause. The terms of the demolition clause are similar to what's in Section 56 of the Retail Leases Act. In essence, what a demolition notice requires under the lease and under the Act is that there is a genuine proposal to demolish the building within a reasonably practicable time, and at least 6 months written notice is given. And demolition is defined in the Act as any substantial repairs, renovation, reconstruction of building that cannot be practically carried out without vacant possession of the premises. And in this case, VCAT granted the interlocutory injunction. In reaching that conclusion, VCAT considered two main aspects to the definition of demolition. The first is whether the proposed works require vacant possession of the premises, and whether there is a genuine proposal to demolish, and that is whether the proposed building works is in fact demolition. In terms of the first question, whether vacant possession is required, the landlord proposes to carry out a redevelopment of part of the shopping centre where the tenant is premised. The proposed works include demolition of premises, dividing the area into two tenancies, building new shop fronts for the tenancies, and servicing works through the premises to service the new tenancy. The VCAT accepted that these proposed works will create significant business disruption. However, it indicates that business disruption does not mean that the works require vacant possession. It states that it's a matter of fact whether the works would require vacant possession. And unfortunately, in this case, the landlord has not provided sufficient evidence to support such facts. And the only evidence provided are affidavit of the landlord and affidavit of the leasing manager of the landlord, which the tribunal considered do not answer the question of whether the works require vacant possession. And the second question is whether the proposed work is in fact demolition. On this point, tribunal first pointed out that the landlord's motivation or objective behind the building works is largely irrelevant. For example, it is irrelevant if the landlord is taking advantage of the demolition clause. What is relevant is whether there is a genuine proposal to demolish. And this comes down to the question as whether subdividing the premises into two separate lease holdings is demolition under the lease and under the Act. And the tribunal applied the general principle of the law of interpretation and considered that demolition should be interpreted as any substantial repair, renovation, or reconstruction which means to restore, to rebuild, or to construct again. The tribunal considered that the proposed subdividing works are redevelopment, which means to bring something to a more developed state. And they do not fall under the definition of substantial repair, and as such, they are not in fact demolition. Other than this case, there is very limited Victorian case law that discusses what constitutes demolition for the purpose of Section 56 of the Retail Leases Act. However, given the almost identical terms in the Retail Leases Act in Victoria and New South Wales, authorities in the New South Wales jurisdiction have been applied in Victoria. And one of the authorities is a decision of the Supreme Court of New South Wales in 1999, Blacklow and Felpio Pty Ltd, where Justice Bryson went into more detailed analysis of what constitutes a genuine proposal of demolition. In Blacklow, the premises is a two-story building where the tenant was using the ground floor to run its pizza shop. And the landlord proposed a complete refurbishment of both floors of the building, including works such as installing new shop front, new electrical wiring, new plumbing works, new ceilings, removal of all kitchen equipment on the ground floor, and installing new toilet facilities. The tenant claims that the proposed works can be carried out without vacant possession. He argues that special measures can be taken so that work is done outside trading hours of the pizza shop, and that cleaning of dust and debris can be conducted so that the premises is available for trade. And essentially, the tenant seems to argue that despite the business disruption, the proposed works can be carried out without vacant possession. Justice Bryson considered the impact of each item of the proposed works, and it's useful to have a closer look at this consideration. The first one is installing a new shop front, and Justice Bryson said that it would cause very little disturbance, as it could be prefabricated off-site and could be completed within 1 day. In terms of installing a new electrical wiring and new plumbing works, it will cause considerable inconvenience, and the business will be interrupted for several days. For removal of ceilings and fixing new ceilings, it will impose larger difficulties, and dust and mess will cause business interruption for several days. And cleaning of the premises right after the work is not realistic, and that despite cleaning, the premises will not be suitable for a pizza shop for at least another few days. And removing all kitchen equipment on the ground floor would be impossible for the tenant to continue with the business. And lastly, installing new toilet facilities would cause inconvenience, but temporary toilet facilities could be arranged. So overall, Justice Bryson considered that the initial works could be performed without vacant possession. However, the business would be disrupted for months. And also at the end of the construction work, the building will not be suitable to run a pizza shop anymore, as the landlord would turn the ground floor into an office area for its own real estate business. So based on these facts, the proposed works are considered genuine proposal of demolition. So what can landlords and tenants take away from these authorities? For the landlords, it's important to make sure that the demolition notices include sufficient details that can demonstrate that it's a genuine proposal of demolition, and also that the proposed works would require vacant possession. And as the VCAT case demonstrates, that the landlord's motivation is irrelevant. And for the tenants, make sure that you are aware of the requirements for a valid demolition notice, and if necessary, potential compensations from the landlord can be requested. And that's all from me today. Thanks very much.
So Zoe, can I start with kind of statements and kind of questions? What some people might be sitting there going, hang on a minute, can they do that about, is the fact that you enter into a 5-year lease with a landlord, and they can walk in one day with a notice and say, I've decided that I'm going to change this and don't worry about it. I'm going to demolish this, you're out. Now, one of the key things is that the lease needs to provide it. And only then does it activate the right to give that notice. So when somebody says, and this is, I guess this is the sell, get some legal advice about your lease, but the next thing is listen to the advice. I find constantly that with clauses like that, I'm saying, do you realise this means this can happen? People frequently say, they're not going to demolish the place. You know, it's great. But these are the types of clauses that do happen, and these are the cases that prove that they do. And it might be a 5%er, but these are the examples of where brushing over the clauses up the back that look standard and seem to, suggest a risk that's very, very small. This is when it's time to pay attention and say no, or say, look, I'm happy for you to have this demolition clause, but I want a pre-agreed compensation arrangement. If you kick me out of my pizza shop, you're going to pay me for my relocation costs, you're going to pay me for my rental differential for the remainder of this term. So these are really good examples of stuff that you see all the time as a standard clause, and you just read past it. There's no, they're not going to demolish it. But when a landlord suddenly says, I've got some cash, I'm getting a really ordinary rent from this pizza shop because it's old and run down, what I'll do, I'm going to do a big refurb and I'm going to double my rent. And, there's capital and tax wonderful things that the landlord might be able to get out of that too. Well, pizza shop owner isn't there or is gone. The earlier one, again, sorry, stealing some of your fun, but the earlier one was a really good example of a landlord in a shopping centre saying, I've got this really big retail space that I'm not getting much out of. I can get 2 shops out of that and I'll get another 50% of the rent. And dressing, and again, I'm talking from a tenant's point of view, but dressing that up as being, it's a genuine refurbishment. Now in that one VCAT, I think it's a good example of 2 things. Number one, good interpretation and good thinking in terms of let's dig down into demolition, and also of a judge saying, nah, I'm going to find a way around this because this isn't genuine demolition. This is changing this to get a different result. And so they're good examples of what can happen, albeit that it's rare. As a landlord, jump to the other side, my suggestion would always be don't try to hide it up the back. If there's any prospect that you're going to do something like this, get it up the front. You might be a bit scared about whether tenants will pick that up, but you'll have an easier fight if it comes into question. You've been quite up front and your drafting is quite clear. So I just made all those statements. Your question is whether I was right. Which is it wrong? Absolutely. Right.
Very good summary.
I'm sorry. But there's, the takeouts include, in addition to some of the technical aspects, are that there's some, real commercial grunt behind these sort of these cases. So thank you very much, Zoe. Really, really interesting, but also some salutary stuff. There'll be a couple of people going home to check their lease, I suspect. All right, thanks, Zoe. Val is next, because Julie just pointed at him and said, so Val, take the stage, my friend.
Good morning, everyone. Oh, that's me. As Rick has indicated, I'm one of the senior associates and I've recently. Today, I'm going to be talking to you about the topic of material facts and the effect of misrepresentation with respect to sale of properties. So there are disclosure obligations for vendors according to Section 32 of the Sale of Land Act of Victoria. The vendor must provide the purchaser with a signed statement which discloses a number of issues under Section 32. Section 32I to 32K covers those aspects. The intention behind Section 32 statement is based on consideration, and that there is a saying that information is knowledge and knowledge is power. And a purchaser is able to make an informed decision and judgment on whether they should purchase a property based on the information that a vendor discloses. Now, the obligations under Section 32 is not exhaustive in covering all aspects that potentially a vendor needs to disclose. But if a vendor does satisfy the requirement under Section 2, they have met their obligation. I have actually read an article yesterday with respect to a defective Section 32 and it's been posted on LinkedIn. So if anyone's interested to have a read of that, it's available. The question is then, what other important matters a potential purchaser is ought to be made aware of that is not included in the Section 32 statement? From 1st of March 2020, there has been an amendment to Section 12 of the Sale of Land Act, which deals with material facts. In summary, Section 12, subsection D, makes it a criminal offence for any person, which will include vendors and their agent, to intentionally induce a purchaser to buy property by knowingly or recklessly making or publishing false representation of false promises. It further makes it an offence if a vendor or agent makes or publishes misleading or deceptive statements or knowingly conceals any material facts. Now, if found guilty, a vendor or agent may be liable to a penalty of not more than 120 penalty units or an imprisonment for a term of not more than 12 months. Now, the Sale of Land Act does not define what material fact is, nor does it provide examples constitutes an offence under Section 12D of the Sale of Land Act. We must then turn to court decisions. However, even they are not definitive examples to provide us of what material facts are. Now, are there any horror movie fans in the audience? Yeah? So you know that when in typical horror movie films, someone buys a house where there has been a mass murder, I would consider that to be that would obviously prevent someone like me with a bit of a scaredy cat to purchase that particular property. Now, Consumer Affairs Victoria agrees with me, and they have prepared some guidelines. And some of the guidelines or examples in the guidelines of what material facts can include, it is when a vendor has conducted prior tests on the property and it demonstrates there to be contamination, they have not revealed that, that is a material fact. Issues regarding cladding, that is a material fact. If there is asbestos or termite infestation, that is a material fact. If there is any underlying cause of defect in the structure of a property that the vendor is aware of, with defective stumping causing cracks in walls. The guideline can be found online if anyone is interested. Now, turning back to my example with the horror movie, they also include any extreme crimes which have been committed on the property, such as homicide being a material fact. So, breach of the Section 12D may result in criminal liability by a vendor. However, it does not create any legal rights in favour of a purchaser that has been affected by such breach. We then turn to Section 48A of the Sale of Land Act, which the exact reading provides Sections 125, 195 and 196, Part 8.2 of the Australian Consumer Law and Fair Trading Act 2012 extend and apply to this Act as if any reference in those provisions to the Australian Consumer Law were referenced. That. Now, Part 8.2 of the Australian Consumer Law contains Section 217, which provides for actions for damages and enables any person who suffers loss, injury or damage because of a contravention of a provision of this Act may recover the amount of the loss or damage or damages in respect of the injury by proceeding against any person who contravened the provision or was involved in the contravention. Now, the involved in contravention aspect would tie in with vendor's real estate agent. So the combined effect of the provisions means that a purchaser can bring an action in VCAT to recover damages against the vendor or an agent. There is a case example on the screen, and in summary, the case relates to a purchaser who purchased a property from the vendor in 2009, so a while back. The purchaser initiated proceedings in VCAT against the vendor for a breach of the Sale of Land Act. The vendor entered into a Section 173 agreement but failed to disclose this to the purchaser. The relevant planning requirement was a condition in the planning permit that the council had issued the vendor in 2008, a year prior to them entering into the contract. The permit allowed the use and development of a dwelling on a parcel of land, which included the land that was later sold to the purchaser, and also allowed the removal of vegetation on that particular land. The agreement required the vendor to fence off and revegetate some of the land, and that registration with the Land Titles Office would find the purchaser. The vendor entered into this agreement after signing the contract with the purchaser, but before the actual settlement. The Section 32 statement that was provided did not disclose the planning permit or the condition of the Section 173 agreement. Now, the dispute arose when the purchaser supported the vendor in an application to VCAT to have the condition in the agreement removed. The purchaser was then charged legal costs by its legal representatives in the sum of $5,048.39. The purchaser then sought this payment from the vendor, and the vendor failed to make payment. The tribunal ultimately concluded that the vendor had contravened Section 32 of the Land Act because the planning permit contained condition which was an approved proposal, which is covered by Section 32 that required the vendor to disclose, but they did not. The tribunal further concluded that while the contravention occurred in 2009, before the Australian Consumer Laws came into effect in 2012, by virtue of Section 217, VCAT had jurisdiction to award loss suffered because of the contravention, and accordingly ordered the vendor to pay the purchaser $5,048.39, which is some key takeaways. A breach of Section 32 only allows for rescission under Section 32K. Any loss suffered by a purchaser as a result or failure to disclose is compensable. A breach of Section 12, which deals with material facts, allows for a purchaser to take an action pursuant to the Australian Consumer Law. And Section 117 confers VCAT jurisdiction to deal with an application for debt. Another case, which is a Federal Court of Australia case, this one deals with an off-the-plan property. In this particular case, the vendor agent prepared marketing materials, and as part of the marketing material, it was advertised and depicted that the property was constructed with a freestanding opening and continuous transition between internal living spaces and the outside areas. Now, the vendor, being the developer, was made aware that that would not happen, but nevertheless still proceeded to sign the contract with the purchaser. The purchaser entered into the contract on the belief that the apartment was going to be constructed as how it depicted in these materials. Interestingly, in this particular case, though, there were clauses in the contract that excluded the rights of the purchaser to rely on any visual representation or anything that is not written in the contract. What the clauses, however, did not exclude were statutory remedies available under the law. The purchaser then sought to terminate the contract because the agent's marketing material was not what they had wanted. And it proceeded to court and was found by the Federal Court of Australia. The purchaser was, in fact, relying on the marketing material and would not have entered into the contract had they known that the apartment could not have been. The Federal Court then ordered for the contract to be terminated, and pursuant to Section 237 of the ACL, allowed the court to order damages. Some key takeaways with respect to this matter: visual representations and verbal warranties, which may be misleading or deceptive, must be corrected in a contract of sale, as the accuracy in the description, even for property that's not yet to be constructed, may be relied upon by a buyer, which may give rise to a claim under Australian constitution. The other final key takeaway is that while there may be disclaimer clauses prepared by solicitors which exclude purchasers from relying on anything that's not included in the contract, those clauses are insufficient insofar as it does not protect the seller from a claim for statutory remedies under the ACL. That concludes my part. Is there any questions?
Given that the age seems to be exposed under that led to changes in the term way that agents go about engaging with their clients, and list of interrogatories or requisitions, or
Sometimes yes and sometimes no. Obviously, an agent's task is to ensure that the property is presented in a way where the potential purchasers would be interested in buying. I would say that vendors should probably check the advertising materials that an agent out and just not place all the trust on an agent.
sorry, I meant more like agent. Us.
Yeah. So we work with agents, property lawyers. And part of the process, we usually send out very detailed questionnaires about the property. Those questions do contain matters with respect to the Section 32 requirements of disclosure, but we also ask our clients if there's any other material matters which would impact a decision of a potential purchaser for disclose. Obviously, it's relying on them actually disclosing that to us, but we will give advice to the client to say, well, these are the ramifications if you fail to disclose that. And then from that, we will then work closely with say, look, other than the Section 32 matters, there's actually these sort of material matters that you should be advising purchasers.
One thing I'd say too, John, is one thing I'm noticing is what is coming in Section 32's is a little bit more information. So I saw a Section 32 the other day that had an asbestos report attached to it that was all about the common property, not the particular unit. And I looked at it and I thought, you wouldn't have seen that 5 years ago. You didn't, if you hadn't specifically asked a question that put them on guard and got them to disclose it. And even then, maybe not. You're now seeing a little bit more meaty stuff coming in the Section 32s, I think, because of these changes. So one of the things is because they're relatively recent, we don't have the cases yet. It's 2020 that this was brought in. One of the difficulties with it is you tell me what a material fact is, because in classic, and we're seeing it sadly more and more in a lot of legislation, a term like that is thrown in there that has such a huge, breadth of interpretation without any detail at all, any context at all, and you don't know until 20 years later when the courts are finished, what's going to come within it.
I would say, Rick, I think it's against general buyer notion that, you're a purchaser, you should go and make your own inquiries about these things, placing more obligations on yours to close things like contamination, which ordinarily we would say there's a contamination, you go and figure out that's there or not.
Can I ask, I'm real estate agent myself, and
sometimes, I always, instruct my, client to go to solicitor. Because, you got all, that you know how to work properly more than a conveyancer. But in the case, because like someone that is a bit cheaper for me, But, if like the conveyancer did repair section 32 with the missing, like you mentioned before about, and so who will be, the buyer issue the conveyancer or agent. Not in that case, because we're not, sometimes we're not the one to introduce or
So when I made reference to the article yesterday, it's actually an article relating to a vendor was sued in this particular matter for not preparing the correct section 32. The case was about the fact that in the section 32, the conveyancer had clerically done an error and had marked that wastage systems were connected to the property, but in fact that it wasn't. The property was reliant on wastewater and septic tanks. Now, under that particular council, there were a waste management plan that had many conditions that required the vendor to maintain and also cost them money to maintain. In that case, the vendor tried to use the excuse of, I went to a professional conveyancer to get these documents signed, to get these documents prepared. That argument did not fly, that particular. And the reason is a vendor statement is a very important document. A vendor must sign the document to confirm that the facts in the section 32 are actually correct. So it was deemed that the conveyancer actually did nothing wrong because they were reliant on the materials from the vendor to prepare the 32. I would say though that in the event where you later recognize or find out that your section 32 is somewhat defective, at the earliest opportunity, correct it. Get instructions from the vendor to send out an email correspondence to the purchaser, just letting them know that there's something wrong with the section 32. Because it does excuse a vendor under the provisions that will prevent a purchaser from terminating if the vendor has acted honestly and reasonably. So that's what.
Thanks, Val.
Thanks.
Again, it's a really good example of the standard clause you'll see up the back of a contract, something that says any representation or warranty that's not explicitly stated in this contract is excluded. And people who actually read all the way to the back will often read that and again say, there's two things about that. If you're the person who's buying, you need to then turn your mind to, is there anything they've told me that I require? So the first thing is, don't rely on this as a purchaser as saving your life if you find out something later, because it's not as simple as, oh, they didn't tell me something. It is bigger than that. So number one is, and I always ask of my clients, is there anything they've told you that you're not seeing in this contract? Any promise they've made, is there anything they've told you that is important to you? And as from the buyer's perspective, it would be all about making sure that there's a special condition in there that recites that. And in fact, there's been occasions where when we've tried to insert that, it's actually the vendor has run a mile and refused to have it in there because in fact it was a lie. And that's actually borne that out. It's actually been like a prenuptial negotiation. Deal didn't go ahead, and thank goodness from the buyer's perspective. Vendor's perspective, this stuff is new and hot. As Julie said, buyer beware doesn't exist anymore. And without, consumer protection is important, and there are a lot of vulnerable people, but there's a lot of smart people too. And, what we're seeing more and more is that responsibility for looking after the other side of the transaction is being pushed, particularly to vendors. And so the material fact stuff is a really good example. But again, it's about asking questions of your client, whether you're the estate agent, the lawyer, but also very much with Section 32s, the vendor themselves has to read it. They have to read it. And the days of saying they haven't asked, so don't tell them, they're over. That's the other big takeout. Thanks, mate. Well, yeah. The very wonderful Julie Maxfield will now speak about retail premises leases, which is a matter that I know you spend day after day. It's really close to your heart. So enjoy sharing.
Thanks everyone. I looked a bit skinnier then and more tanned. Must have been in summer pre-COVID. I'm going to talk basics retail leasing today. Zoe touched on obviously demolition notices, which is a more specific topic. Given the state, obviously, of the market now, walk down Little Collins Street of a morning, my favourite convenience shop is gone. There's vacant shops everywhere. So it's a topic at the moment that's important for landlords and tenants that are negotiating a new lease as to whether the Retail Leases Act applies, and I guess the difference between what people see as the commercial lease and what is known as the retail lease. So I'm going to touch on a couple of cases that talk about goods and services in the retail sphere, and also the application of the Act and what that means for landlords and tenants, which they need to bear in mind when they're negotiating through agents or without an agent the terms of a lease. So the meaning of retail premises. So the Retail Leases Act applies to a retail premises lease that is entered into or renewed after the commencement of the Act. Those words will come back to shortly as to entered into or renewed after the commencement of the Act. And Section 4.1 of the Act defines a retail premises to mean premises not including any area intended for use as a residence, but under the terms of the lease relating to the premises used or to be used wholly or predominantly for the sale or hire of goods by retail or the retail provision of services. And that's the most important, I think, aspect that we'll be talking about shortly, or the carrying on of a specified business, a specified kind of business, the minister determines business. There also are some specific exclusions under Section 4 of the Act. So premises where the occupancy costs, that's basically rent and outgoings, under the lease are more than $1 million. Premises that are used wholly or predominantly for carrying on the business by a tenant on behalf of the landlord, as the landlord's employee or agent. Premises where the tenant is a listed corporation or a subsidiary of a listed corporation. Premises, the tenant of which is a body corporate whose securities are listed on a stock exchange that is a member of the World Federation of Exchanges, and that's international companies. So Lululemon, for instance, companies listed on the NASDAQ, like that sort of thing. And certain types of leases and tenants are prescribed by the minister. So that is under the Act, the minister's made determinations that certain premises aren't retail premises. For instance, barristers' chambers are not retail premises. Leases in the Melbourne Market Authority are not retail leases. Certain charitable leases and community recreation leases where the rent is below $10,000 are also not retail leases. So the consequence, though, of the application of the Retail Leases Act is pretty important for landlords and tenants. And there's probably four main reasons why, and they really do have a financial impact on the terms of the lease and negotiations that take place if they're not considered properly. So basically the main four consequences of the application of the Retail Leases Act. The main one that everyone talks about, I think, which is pretty common, under a retail lease, a landlord cannot recover land tax from a tenant. So at the moment where you've got vacant shops, a lot of negotiations in place, tenants got a lot of choice about where they want to go. If the Act applies, a landlord can't on-charge land tax to a tenant. So that's obviously a financial consideration for both parties when they're negotiating the rent and other. The Retail Leases Act has a general prohibition on a tenant being required to contribute to capital costs. That's also another issue where, unless there's limited circumstances where that can be allowed, but they need to be specifically set out in the lease and certain aspects of the retail lease. There's a requirement that a tenant shall not be required to pay outgoings unless they're provided with an annual estimate of outgoings. And one thing that a lot of people forget in this sphere about the Retail Leases Act is an entitlement to a tenant for a minimum 5-year term. So that has a couple of offshoots. The first is you might agree, landlord and tenant agree that the Act applies, everyone knows the Act applies, and they say, oh, do you want a 3-year term? So the tenant and landlord say, yep, let's have a 3-year term. They enter into the lease. The landlord's got plans for this premises for year 3 and 1 day, and the tenant turns around and says, well, actually, I'm entitled to a minimum 5-year term under the Act. Despite what we've agreed, I'm going to stay here for another 2 years. So, and that tenant will be permitted to do that. In terms of an agreement for a term that's less than 5 years, there is a way that that can be sanctioned in effect, and that requires the tenant to go off to the Small Business Commissioner, make an application, they provide a copy of their lease, they get what they say is advice about their rights to a minimum 5-year term, and they basically waive that advice. So the tenant then gets issued with a certificate from the Small Business Commissioner, which basically is a 5-year waiver certificate. So you can have a lease under 5 years as long as the tenant goes off to the Small Business Commissioner and gets a certificate that basically waives their rights. So I'm going to talk about a couple of cases which sort of centre around whether the Act applies in relation to goods and services. And the test that basically the courts have been using for a number of years is called the ultimate consumer test. And that's been debated, I guess, for a long time. And recent cases have reinforced that test. And basically, the test is whether the goods and services are being supplied to a consumer who uses those goods or services as the end user. So while the court and the tribunal do take into account other factors when they look at that, as to whether the Act applies, the ultimate consumer test is a test that has been used for decades, essentially, probably almost longer than when Essendon last won a final. But that is how long that's been used for and debated. So the main case around this is the CV cold storage case. Probably taken a bit of a hiatus over the last couple of years while we've been discussing COVID rent relief and all of that sort of thing, and hiding in our kitchens and lounge rooms working from home. But this case has recently been considered again. So I'm just going to quickly run through the facts behind that case, and that will lead us into our next case. So the landlord in this case leased the premises at Laverton to a tenant that operated a full storage business which had freezer warehouses built on the property. Tenants' customers paid a fee to store their food, essentially their food products, small goods, etc., and seafood at the premises. The sorts of customers that stored there were producers, manufacturers, distributors, importers, and exporters. The tenant also provided ancillary services to customers, such as unloading and loading of the stock, and then certain transport services as well. And it's one of the factors that we'll consider this was the tenant's business was open during normal business hours to the public. So what happened here is the tenant brought a claim in VCAT seeking a recovery of money it had paid to the landlord on the basis that the Retail Leases Act applied, as the tenant claimed that these premises were retail premises. Essentially, what that was the claim for repayment of outgoings and land tax that basically they shouldn't have paid because the Act applied. And the answer to obviously the question as to whether the Act applied basically turned on whether there was a retail provision of services. So was the tenant providing services to end consumers who use those services. At first instance, VCAT held that they were not retail premises, and then the Supreme Court overturned that decision and found in favour of the tenant and said that the premises were in fact retail premises. The landlord then appealed to the Supreme Court of Appeal, and the appeal was dismissed. So essentially the Supreme Court reaffirmed the decision, reaffirmed the decision of the Supreme Court and found in favour of the tenant. So the court held that the phrase retail provision of services has long been interpreted by reference to the ultimate consumer test, that is, are the services used by the person to whom they are sold or are the services passed on by the purchaser in an unaltered state to some third party. And in this case, the services of the storing of the fruit and the poultry and the seafood was used by, they say, the people that use that service were the end consumer of those services. So they weren't storing that food on behalf of someone else, they were doing that for their own purpose. So the court said they were the ultimate consumer, and that the ultimate consumer test was satisfied, so that the services were retail services. Some other comments that were made were they didn't draw a distinction between commercial and non-commercial users of the service. So essentially, if mum and dad wanted to go in there and store their chickens in there for Saturday night dinner, that was okay. They said that the court should be slow to depart from the interpretation of the phrase that's been given to it by the court over many years. And during that whole time that the ultimate consumer test has been applied, the legislation has been altered in terms of the application of the Act, but there has never been a change to the phrase retail provision of service. The court also said that other relevant considerations as to whether the service retail in nature include the type of the service that is provided and whether it is generally available to any person for a fee. That last one, whether it is generally available to any person for a fee, leads into the next case that I'm going to talk about, which relates to goods. And this is the case that was in VCAT this year, so it's a pretty recent decision. Facts of this case are that the tenant supplied stainless steel products to customers, which included members of the public. The tenant's preferred method of sale was by pre-arranged appointments. So this property had a warehouse on it with an attached office. People would ring up and say, can I come and make an appointment at 2:30 to come and see this, essentially. The external office door was locked for security and safety reasons, and we'll come back to that aspect later because that has a bearing on whether the premises were generally open to the public. Members of the public gained entry through warehouse doors, which were open between 6:30 a.m. to 3:30 p.m. Monday to Friday. When a customer went there, they were always escorted by staff throughout the warehouse. And there's also evidence was given that they had to wear high-vis jackets, there was a lifting of steel, there was cranes in there moving around at the same time. Products were able to be purchased at each of the warehouse and the office. There were business signs placed outside the warehouse doors and at the warehouse store. So the case talks a lot about these A4 signs that were up outside the window to the office, which I found quite interesting that they really focused on the fact that this one paid for it. The tenancy commenced in 2017, and in 2020, the tenant claimed that the Act applied and sought recovery of land tax and other outgoings paid to the landlord in relation to essential safety measure payments also. So the important part about that is that the lease commenced in 2017, but it was in 2020 that the tenant made this application. So the tribunal held in this case that the ultimate consumer test was not satisfied. So they said, and this largely turned on the evidence of the case. There was no evidence of how the purchasers used the products once they were purchased from the premises. So that wasn't really led by the tenant to say that these people that purchased the steel actually used them for their benefit. There was no evidence really led that what they were used for, and there was no evidence about the proportion of sales made to the ultimate consumer to satisfy the ultimate consumer test. So I guess that follows on from what I said. They couldn't provide appropriate evidence, and I think their evidence, upon reading the case, was a little shady, one might say. But I think there was no evidence that said this percentage of people used the steel for their own benefit, and this is what the businesses did. So basically, VCAT said that the ultimate consumer test was not satisfied. They also said that the premises wasn't open to the public. So they said it was not in dispute that goods are available to anyone willing to pay the fee. basically mum and dad could go there, a business could go there, but the evidence did not go far enough to establish people can go and buy steel from the premises. People could not go to the premises unaccompanied and their access was restricted, so it was by appointment generally. They had to have someone with them, and they were only open during certain times. They said the signage was a factor to consider, and even though it was limited, it was basically said that the signage did not invite the general public to enter. Probably fair given it was. There was, so basically the tribunal said there was no evidence to suggest the use of the premises of retail use at the start of the lease. So that is when the relevant time to determine whether the Act applies is. So the relevant time is at the time the lease was entered into or upon renewal of that lease. So if this lease was renewed and the circumstances had changed, the Act might apply at that stage. But the Act didn't apply in 2020 because they said in 2017 when the lease was entered into, the premises was not a retail, there was no retail use against it. And the tribunal basically said on the balance of all of the evidence, it wasn't shown that the present premises were being used wholly or predominantly for the sale of goods. So the key takeaways from both those cases, I guess, and the recent revisiting of the CB cold storage case by the tribunal, that they do seem to be taking a practical approach. They look at all of the circumstances of the case. And in the most recent case, they referred to these matters as matters on which the tribunal has regard to. So nature of the goods or services offered, whether a fee is paid, whether the goods or service is generally available to anyone willing to pay the fee, whether the ultimate consumer test is satisfied, whether the premises are open to the public in the required sense, whether the test is satisfied at the time the lease is entered into. Obviously, from our perspective and from landlord and tenant's perspective, should give consideration when drafting any heads of agreement, terms of the lease, including in relation to the permitted use. So they do touch in the cases about clauses that say you can't use this for any retail use. A lot of leases say that. While they don't sort of make a definitive statement on it, in the cases they do have regard to those clauses, but basically they say if the tenant is complying with the permitted use, then those clauses don't matter. Outgoings, obviously, that the landlord desires to cover, so that will be land tax, it might be a contribution towards essential safety measures, it might be a contribution towards certain capital works. And then obviously the term of the lease. As I said previously, there's a minimum 5-year term for tenants, which does catch a lot of people out. We see it all the time. I'm sure Barrel will agree that you get a heads of agreement that says it's a retail lease and the term is 2 years. And I will just say that that minimum 5-year term does include any option. So if it's 2 years plus an additional 3 years, then that will comply. The other thing in relation to the term, retail lease, that doesn't generally apply to a lease with a term less than 1 year. So you might see sometimes short-term leases for 364 days. But as soon as that rolls over to your 1 year term in overholding, the tenant will have a right to a 5-year term. That's it from me.
Terrific, Julie. And well, unfortunately, because there will be a range of questions arising from that simple opening presentation, it is 9 o'clock and we're going to stick to our plan. But anybody who has a question, please stay and ask it. And anybody at home who's got one and also has a telephone, please feel free to give a call. To those who are at home, I understand there was some technical difficulties during the course of this presentation, for which we sincerely apologise. But the entirety of it has been recorded and will be available later if you want to catch anything you didn't see. Thanks, Julie. I think you got the key takeouts. Key takeouts are, if you don't want it to be a retail lease, make sure it's not a retail lease. And if you do, make sure it is. But there's grey areas and you don't get to choose. That's the important thing. You can't put in a lease, this is or is not. It either is or it's not. So thank you very, very much to our wonderful presenters. We do have a forum coming up on the 21st of, sorry, 2020. What's the other date? Yeah, 21st of September, 6 p.m. That's going to be an evening one. We have a wonderful speaker from the ANZ, Adelaide Timbrell, who's going to be speaking about the economy and the ANZ's views on it. And we'll be there, you know, pretending we know what she means. And so please keep an eye out for that one, and we'll send out some material about it. Thank you very much for our presentation. Thank you all for attending, and for those at home. Thanks. Have a great day.